All right. Good morning, everyone. Thank you for being here. I want to first, before we get started, just thank you all for being so understanding and cooperative. This has been an unpleasant experience for me, and as you can hear from my voice, I'm not in good enough shape to go forward with a full 2-day evidentiary hearing. It would just be a disaster, and I would not be able to give this case the attention it needs, deserves, and requires. So I just really want to thank all of you for being so cooperative and understanding about that. Okay, Tracy, you're online. Are you ready to get going?
I'm ready.
Can you hear me okay?
Yes, I can hear you fine.
Okay, good. If if at any time you can't hear me, somebody just speak up and let me know. I'm going to try and keep this pretty short for obvious reasons. All right, let me go ahead and call the proceeding. We are here on proceeding number 23A-0570G. This is the CAAM application of Colorado Natural Gas. CAAM is the Cost Assignment and Allocation Manual. Today is Wednesday, May 29th. It's 10:30 in the morning, and we are here for a pre-hearing conference that I called yesterday after vacating the evidentiary hearing that was supposed to be held. I will provide a brief summary of all that after I get your appearances. Let's go ahead and start with C and G. Mr. Davidson.
Good morning, Your Honor. Mark Davidson, the law firm Fairfield and Woods, appearing on behalf of the applicant, Colorado Natural Gas.
Thank you, Mr. Davidson. And who is here for staff?
Good morning, Your Honor. Special Assistant Attorney General Mark Valentine appearing on behalf of staff.
Thank you, Mr. Valentine. UCA?
Good morning, Your Honor. This is Assistant Attorney General Patrick Wittershine on behalf of UCA.
Thank you, Mr. Wittershine. And for ARM Heartland?
Good morning, Your Honor. Gabriela Stockmeyer of the law firm Dietz and Davis on behalf of ARM LLC and Heartland Industries LLC.
Thank you, Ms. Stockmeyer. Okay, as I alluded to at the very onset of the hearing, we were supposed to start a 2-day evidentiary hearing in this matter today. However, I, after traveling briefly to the East Coast, contracted COVID and have been quite ill for the last several days. I'm a bit better today, but I'm not in good enough shape to conduct the hearing today. So I asked you all here today so that we can discuss the possibility, actually likelihood, of extending the deadline. Currently, we are under the 250-day statutory time period under which applications that are filed without supporting testimony fall. That deadline would then expire September 12th, 2024. Having to vacate the hearing and reschedule it, however, will make that deadline almost impossible for the commission to meet. Therefore, my proposal was to invoke the provision of statutory section 40-6-109.5, subsection 4, which permits the extension of the statutory time period by an additional 130 days under extraordinary circumstances, but does require the convening of a hearing to establish that such extraordinary circumstances exist. My suggestion is that I invoked this provision, and given that I think we're going to need time to reschedule and time for the commission to issue its decision, I don't really think there's a better alternative than for me to extend the deadline. The new deadline would then be January 20th, 2025. And in order to meet that, I think we could give ourselves until probably September to conduct and to reschedule the hearing and conduct it then. And just to make a record why I can't proceed today, in case anyone listening is wondering, as I said, I contracted COVID. I'm recovering, but I'm just not well enough. I don't have the stamina yet to do a 2-day hearing. I'm really, really, really sorry. And I think I'll be avoiding the East Coast for a long time. But anyway, so my first question to you all is, I want to go check with everyone, starting with Mr. Davidson, and find out if anyone has any objections to my proposal to invoke the extraordinary circumstances provision and extend the statutory time period out to January 20th, 2025. Mr. Davidson?
Thank you, Your Honor. First of all, I hope you're healing quickly and feeling better soon. But on behalf of the company, we don't object to the extension that you proposed. And in fact, in polling the parties, I think we have an agreed to time period for the resetting of the hearing to maybe speed this up even a little bit more. But you can hear from the other parties regarding their position on the extension, but the company does not object.
Thank you, Mr. Davidson. And thank you all for being so cooperative again and working together. I really do appreciate it. And it makes my job easier and my recovery less stressful. So I appreciate that too. Okay, Mr. Valentine, what is your position on behalf of staff?
Staff certainly does not object.
Thank you, Mr. Valentine. Ms. Stockmeyer?
No, Arm and Heartland do not object to the extraordinary circumstances. And we didn't get to chime in yesterday that we're sorry to hear that you are not feeling well. And it's going around, unfortunately.
It is. To go off topic, but I am not exaggerating when I say that every single place we went on the East Coast, like every gallery you went into the museum, someone was hacking away. I was just, wow. So I'm staying in the relatively open air west from here on.
What? I'm scheduled to go back on June 5th. What airlines did you fly?
I honestly don't think it was the airline. We were on Southwest, but everywhere you went, like every museum, every gallery, people are hacking away. And it's not necessarily the natives. I think it's just they had so many visitors in, just so many people. So booster shot and a mask, Mr. Valentine, highly recommended. Woo, yeah. Fortunately, it's not nearly as serious as it was early days of the pandemic. So I'll be fine, but just not fun. Mr. Wittershine, I haven't heard from you. Do you have any objection to invoking the extraordinary circumstances provision?
No objection from UCA, Your Honor, and we agree with the finding of extraordinary circumstances. Thank you.
Oh, thank you all for being so understanding. I'm going to go ahead and do that. I'll get an order issued out on that shortly. Next, let's turn to rescheduling. Mr. Davidson, you indicated that you think the parties have come to a date that works.
Yes, Your Honor. The dates that you had provided yesterday in our exchange of emails, it looks like the dates of the week of August 5th are available for the parties. And I would suggest, because Colorado Natural Gas has its GIP workshop on the 6th, I would propose the dates sometime during the 7th through the 9th. And in doing so, given the estimates of cross-examination, while we had, I think, among the parties, agreed to a 2-day hearing, and part of that was due to one of our witnesses' lack of availability on the first day. But given the estimates of cross, this might be a 1-day hearing. So I would offer to you the fact that maybe we just need 1 day. I know oftentimes the commission likes to reserve a second day just in case, so we don't have to all reconvene later. But given the amounts of cross that were estimated by the parties, it looks like we could do this in 1 day.
Well, that's good news. As you indicate, though, my inclination would be to schedule it for 2. And then if we don't need 2, then we have a happy free day that no one expected.
In that regard, then I'd suggest the 7th and 8th of August as the 2 days for reservation of the rescheduled hearing.
That's fine.
Your Honor, may I sorry, just interject.
Sure.
Arm, Heartland, Mr. Davidson, staff and UCA agreed to those dates. My clients had not yet agreed to those dates. One of the things that is at issue here is there's a complaint case that my clients have against CNG and Wolf Creek. And the original timing of this hearing, the hearing would have occurred before any deadlines in that proceeding. And so that's a little bit of a moving piece. I did reach out to parties this morning on getting an extension in that procedural schedule. And I hadn't heard back. I had heard back from UCA. I hadn't heard back from the company or staff. So I don't know if it, Your Honor, just in terms of if you want to hear more about that, or if it's possibly we could take a quick recess and I could just speak with counsel for the company and staff to get their position on that.
Well, I guess, Ms. Stockmeyer, my question would be is, they're two different things, right? They're not, you have the complaint proceeding, and then this is an application on a similar but not directly related, not directly identical issue. So why do you think that the two are interdependent in such a way that the date of this hearing is dependent upon the date of the complaint hearing?
So it's a little complex, and I know you're not the judge on the complaint case, but part of that case involves the interrelationship between CNG and Summit and Summit's other affiliates, which are at issue in this case. And when the procedural schedule in this case was set, parties were aware of the procedural schedule in that case. So it's tangential perhaps, but I mean, I would like the chance to speak with opposing counsel about my proposal. I just wanted to, at this point, there is no consensus. We hadn't yet agreed to those August dates.
Okay. I'm still not clear though. Okay. So have you not checked with your clients yet to see if those dates are available to them?
I got an email at 9 o'clock this morning from the company saying that the August dates worked for them. And so there wasn't much time this morning to kind of confirm with my clients and confirm with other counsel. And so, yeah, I mean, the other thought, if we could certainly file a motion, if we wanted to set the hearing via a motions practice, that would give parties a little bit more time to discuss this, confer, agree.
Okay, I guess I'm just not understanding. What do you want? Are you concerned that the procedural schedule in the complaint proceeding is going to conflict with this proceeding? Or are you trying to get this proceeding done before the complaint proceeding? I'm not understanding what it is that you're trying to do.
Both of those things. Initially, this hearing was to be concluded before the deadline for initial testimony in that case was one, and also in terms of the August deadlines, there are also deadlines in that case that are at issue around that same time. So I'm just, yeah.
Okay, well, let me hear from Mr. Davidson, because obviously this affects him the most directly. Mr. Davidson, what is your position on this?
Well, as I said, Your Honor, I think we can probably do this hearing in a day. All the testimony has been filed in this case, direct answer and rebuttal. So I guess I'm unclear as to why we can't slip one day of hearing into wherever the other complaint procedural schedule either is or will be. I guess I don't understand why we can't just take care of this matter and get the hearing concluded and move on within the scope of the other procedural matters in the complaint case that Ms. Stockmeyer is referring to. So I think on the company's behalf, we'd prefer to just move forward with the hearing in this case, assuming it takes a day, even a day and a half or two, and conclude this matter.
Okay. Ms. Stockmeyer, when is the hearing set in the complaint proceeding?
So the hearing in that case is mid-September, but there is a direct testimony is June 10th, answer July 18th, rebuttal and cross answer would be August 12th. And I think there's a potential that the record in that case may take some of the information, the public record from this case, into the record in that case. So that was an initial consideration when setting the procedural schedule here. And
Okay. But
I'm not trying to be difficult. I also just, in terms of the timing, unfortunately, in hearing this morning from the company on the August dates, we just didn't have a chance to confer with all of the other council to just discuss this matter. So I apologize for doing it on the fly here. There just wasn't a whole lot of time this morning to discuss this with them.
Okay. Well, if I understand correctly, though, so that there's an August 12th date for rebuttal, which is admittedly tight, but still post-dates the proposed date of this hearing. And the hearing in your complaint proceeding is about a month and a half after this hearing, which would still give you a month and a half to do corrections and file a motion in that proceeding to file any additional supplemental stuff you might need. I mean, is that an option?
I guess it would just be helpful to hear from the company and staff whether they oppose an extension in the other proceeding, and if they don't, then then I have no issue. Just didn't get a chance to hear from them their position on that, which would alleviate any concerns I have.
Okay, so let's be clear. What are you proposing to extend? Are you proposing to vacate the hearing date in the complaint proceeding and
yes,
establish a brand new
about a roughly 2-month extension / continuance on the dates in that other proceeding to basically accommodate the 2-month movement of this proceeding. Among other, there are other issues in that case, but that is one of the considerations.
Okay, Mr. Davidson, what are your thoughts on that?
I was doing other things this morning, Your Honor. I haven't seen the actual proposal from Ms. Stockmeyer that she's reflected. My co-counsel, Adrian Castro, in that proceeding, in the complaint case proceeding, may have conferred with the company, but I have not this morning, so I don't really know what to tell you about the company's position on the potential extension of the schedule in the complaint case. I can check with them and get back to you later today, perhaps, but as I sit here now before you, I don't have an answer.
Okay. Thank you, Mr. Davidson. I appreciate that. Mr. Valentine, would you like to weigh in on this issue?
Yes, in concept, I don't object to the extension. Staff is a party to both proceedings, and in concept, I don't have an objection to extending the schedule in the complaint case, but I haven't talked about dates and I haven't conferred with my client on that yet, and would like to do so. I will be meeting with them today.
Okay, thank you, Mr. Valentine. Mr. Wittershine?
Thank you, Your Honor. UCA agrees with both Mr. Davidson and Ms. Stockmeyer, and I don't think that's inconsistent. We believe that we could have a hearing in this proceeding the week of August 7th and 8th, one or both of those 2 days. And we also believe that the complaint case should be extended for another 2 months.
Okay. Okay. Well, I mean, if sounds like most of the parties are on the same page about that anyway. So what I would propose is that we go ahead and move this proceeding so that we can get on the calendar and make sure things are squared away and have plenty of time to make sure that we can meet that new 380-day deadline of January 20th, 2025, which is, to be clear, a drop-dead deadline under the statute. So I can't do anything else. So we really do have to make sure we give the commission plenty of time to do its work. Excuse me. One question I do have, I can do the 7th and the 8th. The 7th is the commission's weekly meeting. We can be in here in room B. It won't be too much of a problem, and there doesn't seem to be anything else scheduled. Would you consider the 8th and 9th, though, when we don't have to worry about commission weekly meeting at all? Or is the 7th and 8th better for everyone?
for the company, Your Honor, the 8th and 9th is also fine since we're doing a virtual hearing. I wasn't thinking about the potential conflict with the commission's weekly meeting, but I think the 8th and 9th would still work for us as well.
It's not a huge conflict, to be perfectly crystal clear. It's just that then we have to, our legal assistants are kind of spread a little thinner, you know, one doing one hearing and the other doing the other. They can do it. They're extremely good. They're phenomenally good, but
They are good.
but you know, it does spread them a little thin. So the 8th and 9th is a little bit easier for the commission that way, since we're on a Thursday and a Friday.
That's fine for the company as well, Your Honor.
Great, Mr. Davidson. Mr. Valentine, would that work for you?
Indeed, Your Honor.
Okay. Mr. Wittershine?
UCA is available the 7th, the 8th, or the 9th, Your Honor.
Great. Ms. Stockmeyer, does that work for you if we did the 8th and the 9th?
I think just consistent with the discussion, we would reserve the right, if there's not an extension granted in the other case, to lodge an objection to the hearing date, but it's kind of chicken and egg. So it seems like it makes sense to set those dates, and then if we need to move for a continuance, we'll do so.
Okay, I'm fine with that, but I do want to try and get this scheduled if at all possible. I just think failure, if we don't do that, we'll run into other issues. And I just would like to just state that, you know, you still have, it looks like a month and a half between this hearing and the complaint proceeding as it is right now. So I think it probably would be okay regardless. Okay.
If Your Honor would just note, would Your Honor just please note that the agreement was conditional upon that? That would be, I appreciate that.
Absolutely. I'm happy to note that, Ms. Stockmeyer, not a problem. Okay, let me just. Okay. All right. My next issue that I'd like to raise with everybody is, now that we've pushed back this date, do we want to make modifications to the existing procedural schedule to reflect the new hearing dates? I don't know where he's, I know we've got, Mr. Davidson has the motion protective order for the extraordinary protections pending still. I do want to talk about that in a minute, but in terms of the deadlines, are you thinking you're going to want to do additional discovery? Do you want to, I know which deadlines I'm thinking of resetting, but I'd like to hear from the parties as to where your positions are on that. Mr. Valentine, do you want to go first?
Sure, Your Honor. I am sure that Mr. Davidson does not want any more discovery. And you know, as you pointed out in your email, the parties were basically ready to go, and so I don't see a need for additional discovery because we were all ready to go. I mean, I think the party should reserve their rights to file motions and so forth, but you know, I don't see a need for additional discovery.
That is where I was thinking as well, Mr. Valentine.
Your Honor, if I may.
Yes,
thank you. I was going to raise this when you were asking for procedural matters, but you know, Rule 1405D concludes the discovery process 5 days before a scheduled hearing, discovery on the rebuttal case. And since today was supposed to have been the first day of the hearing, on other than the unfortunate circumstances that we're faced with, I was going to request that there be no further discovery in the case because it's essentially an issue other than the evidentiary hearing. And it sounds like Mr. Valentine's thinking similarly, and I appreciate that. But I don't think there's a need for any additional discovery that's directed at the rebuttal case at this time.
Thank you, Mr. Davidson. Mr. Wittershine, are you in agreement with Mr. Valentine and Mr. Davidson?
Yes, UCA agrees with staff and Mr. Davidson.
Great. Ms. Stockmeyer.
Yes, Your Honor.
Okay, wonderful. Again, thank you all for being so accommodating and agreeable. So the areas that I was thinking you might want to modify the procedural schedule that should, I can't even put a sentence together, I'm so sorry. The topics in the procedural schedule that I think should be modified under this new hearing date are the deadline for corrected testimony and exhibits, because as Ms. Kunkel was looking over them exhibits, there are still some corrections that need to be made. We have to have the certain heading on each page, and it must be on each page, and there needs to be a page number, and the pages, I think they need the case number, page number, whose exhibit it is. She had a whole list, and that needs to be on every page of every exhibit, and not every page had that. So that still needs to be done. So I would suggest that we have at least a deadline for corrected testimony and exhibits. You've already filed a cross-examination matrix. So I don't think we need to do another one of those. I think we're good. But I would recommend a new settlement deadline, because with additional time, I'm going to encourage you to discuss. Maybe this is something that can be resolved. Who knows? So let's set the deadline for that. And then possibly this is up to you if you want a pre-hearing motion deadline. If something comes up between now and a scheduled hearing, that's probably a good idea to have as well. So what are your positions on my proposal with the terms of those dates? Moving those points on the procedural schedule.
On behalf of the company, Your Honor, we're fine with moving those dates out to correspond to the prior procedural schedule. If that's what you had in mind, that would work for us. And we'll endeavor to get any corrections to the testimony and exhibits of the company in place well in advance of any deadline that we do set here, but we'll get that sorted out right away. I think a new settlement deadline makes sense, and pre-hearing motions deadline moved out as well, especially to the extent Ms. Stockmeyer feels a need to file a motion with respect to the schedule at a later time.
Exactly. Just to be clear, Mr. Davidson, I was thinking of massaging the time period ability, because we were on a very, very tight schedule before. So yes. I was going to spread it out a little bit more than, I personally find it much more helpful to have a settlement deadline about 2 weeks pre-hearing. I think that alleviates the burden on the parties and me to do a lot of prep work if you're going to come to a settlement anyway. The same with the pre-hearing motion deadline. That's, I prefer that to be about 2 weeks pre-hearing so that I have time to consider it. If you file it, with 5 days before, chances are I'm not going to have time to issue a ruling before the hearing. That's tight. And corrections, I think that could be a week before. That usually works fine. Does that seem reasonable?
Those timeframes work for the company, Your Honor.
Okay, so then what I would do is set a settlement deadline and a pre-hearing motion deadline for, hang on, that'll fall on July 25th. Okay, and then the corrections would be due August 1st. All right, and now let me hear, Mr. Valentine, what is your?
That all makes sense for staff. Thank you.
Great. Ms. Stockmeyer, does that make sense to you? Does that work?
Yep, just with my same reservation of rights, no objection on those.
I honestly took time to write it out, so I've got it there for your conditional approval.
I appreciate that, Your Honor.
Of course. Mr. Witterschein?
That all works for UCA as well, Your Honor.
Okay, great. Okay, then the last issue I wanted to raise was the pending motion for protective order affording extraordinary protection for highly confidential information. I've read through that. I read through your response, Mr. Valentine. I've taken a gander through the affidavit. Though Mr. Davidson, I'm not sure you're going to like what I'm going to have to say, but I've read through it and I'm not convinced that it clearly and completely provides the detailed description as required by Rule 1101B1. Reading the motion, I'm just not sure exactly what documents you're trying to protect. And I don't think anyone has, I certainly don't have an objection to protecting documents, but I need to know generally what they are, and I'm having trouble based on the motion envisioning what they are. Do you want to expound on it or possibly entertain the idea of withdrawing this one and filing a more detailed version that may even then be unopposed? What do you think?
What I would say, Your Honor, in response, I guess, is a little bit of an awkward situation to provide too much description in
I
a
understand, yeah.
publicly filed motion that, because the company considers this information so commercially sensitive and confidential. So that's the challenge that we have in describing it more fully. That said, I would be willing to confer with the company and see if we can come up with some additional descriptive material information and supplement our pending motion, if that's acceptable to you, rather than withdrawing and refiling, and try to perhaps even work with Mr. Valentine on a more fulsome description that would meet the concerns that you've expressed and that were raised by staff. I don't know what that might be as I sit here today without conferring with my client, but I would offer that as one potential solution to the challenge that we've got and how we're trying to avoid too much description, but give you enough information to make a ruling in favor of extraordinary protection.
Thank you, Mr. Davis. And I do completely appreciate the difficult position you're in, but as it stands now, I don't even know what we're talking about.
Okay.
Bank record. I feel a little in the dark and would appreciate a bit more detail. Mr. Valentine, what is your position?
Well, I'm certainly willing to work with Mr. Davidson on this. We've had an ongoing discussion the whole case about what needs to be provided and what doesn't. I think that staff's frustration at this point is that it's kind of like even the existence of some documents is a subject to a motion for extraordinary protection, and the unwillingness to actually state even a category beyond corporate documents. It's a little bit frustrating to staff. It's not what the commission's rules contemplate. And, of course, I'm willing to talk more with Mr. Davidson about this. And I want to confer with my client too. This is getting expensive for this motion and this issue. This issue has been going on for quite some time. I'm willing to work with CNG. I'm willing to entertain what they provide. If it can be unopposed, that's fine too. Staff reserves its right to file a supplemental response to anything that's filed. We can go from there.
Thank you, Mr. Valentine. That all seems reasonable. Here is my proposal, gentlemen. This is what I think we should do. Do you think that within 1 week, or today's Wednesday, so within a week you could get together, try and hammer out a more detailed description for my benefit, to the extent it doesn't infringe on the company's need to keep things confidential and private and out of the public realm. I totally understand that. But as it stands right now, I don't even know what we're talking about. So I need a little bit more description in order for me to even issue a ruling. So I would like to defer my ruling on this motion for the protective order and ask Mr. Davidson to try and come up with a supplement. I think that suggestion works great, and file it within the next week. Please try to get together with Mr. Valentine if you can hammer it out. and then I'll consider it after that. Mr. Davidson, how does that sound to you? Can you do that within a
That
week?
timing, that works for the company, Your Honor, and thank you for your indulgence. As Mr. Valentine said, he and I have conferred about this on a number of occasions as we've worked our way through this case, and I appreciate both your and Mr. Valentine's willingness to allow us to try to work out a better description that will satisfy your concerns and also meet the staff's needs.
Perfect. That would be great, Mr. Davidson. Mr. Valentine, are you all right with that proposal?
Thank you, Your Honor. That works.
Great. So I will expect a supplement in 1 week and try and get a better description of what we're talking about here. And like I said, it doesn't have to be, page and line of everything, obviously not, but, a little bit more than corporate documents, which basically doesn't tell me anything.
Understood, Your Honor.
Thank you so much. All right. Those are the issues I needed to address. Does anybody have anything else they want to discuss while we're all on this hearing still? Mr. Davidson?
Nothing more on behalf of the company, Your Honor.
Great. Mr. Valentine?
Staff is set. Thank you, Your Honor.
Great. Mr. Wittershine?
No, Your Honor. Thank you for being here today.
Thank you. Ms. Stockmeyer, anything else?
Nothing further. Thank you, Your Honor.
All right. I want to again thank you all for being so understanding and cooperative. It made it a little bit easier. I appreciate your willingness to reschedule this under the circumstances. I will get a decision drafted as soon as I can, extending the deadline under the extraordinary circumstances provision and rescheduling the hearing for August 8th and 9th, and included there the condition that Arm Heartland is reserving its right to object to that date if they're unable to do anything with the complaint proceeding hearing. Okay, great. Anything else?
Chicken soup, Your Honor. Chicken soup.
Fortunately, my husband is an excellent cook, and so I can't say that the kitchen looks good, but that's a different issue. So thank you all for being here. I really, really appreciate it.
Thank you, Your Honor.
Thank you for your kind wishes, and I will hopefully see you all soon.
Thank you, Your Honor.
All right. Bye. We are adjourned.